Hello and welcome to Jurisage Academy's YouTube channel. In this series of Know Your Case Law, we are going to take the case of State of Kerala versus K. Ajith. It's a two-judge bench decision delivered in 2021, which deals with the issue of parliamentary privilege and the immunities that are granted to MLAs so far as criminal prosecution is concerned. So let's start with the facts of the case. So in this case, there were some MLAs of the Kerala Legislative Assembly against whom an FIR was registered for destroying public property inside the house in 2015 during one of the sessions of the Kerala Legislative Assembly. Thereafter, the police report was also submitted and cognizance was also taken on that police report. But in 2018, the Assistant Public Prosecutor filed an application for withdrawal of prosecution under Section 321 of CRPC, citing many grounds, primarily relating to the fact that MLAs enjoy certain privileges and immunity under the Constitution, and this is why continuing with the criminal prosecution is not in the best interest. However, the court of CJM did not agree with the reasons stated in Section 321 petition, and they refused to grant consent to this, which was later also confirmed by the High Court. Now, against this refusal of grant of consent by the High Court as well, an appeal is preferred to the Supreme Court to permit withdrawal from prosecution under Section 321 of CRPC. Now let's see the two important issues which the court decided in this case. The first was that what are the grounds on which grant or refusal of withdrawal from prosecution under Section 321 CRPC is permitted, and secondly, what are the immunity and privileges of MLAs under Article 194, and do these immunity and privileges also extend to protection in cases of destruction of public property? Important legal provisions were Article 194 of the Constitution, which talks about the power, privilege and immunity of the members of Legislative Assembly, and Section 321 of CRPC, which talks about the procedure for withdrawal from prosecution. Now let's come to the main findings and see the reasoning given by the court on these issues. So on the first issue of whether withdrawal from prosecution under Section 321 CRPC should be permitted or not, the court firstly referred to the principles laid down in Shonandan Paswan versus State of Bihar case, which has clarified the principles on which withdrawal can be permitted. So the court held that the exercise of power under Section 321 is first of all a supervisory power. Secondly, court has to ensure that the public prosecutor has applied his mind to the facts of the case and is not doing so only on the advice of the government. Thirdly, the court said that consent may be given if there is paucity of evidence or application is made in good faith, if it is in the interest of public policy and justice, and if it is made not to stifle the legal process. So in this case, the court found that the application, even though it may have been made in good faith, is a valid criminal prosecution, and it is not in the interest of public policy and justice to grant this particular consent. Now coming to the second important issue, which is a constitutional issue as to what immunity and privileges are granted under Article 194. So the court firstly in detail discussed the scope of Article 105 and 194 of the Constitution. Then they talked about the nature of privileges and the reason why they are granted. So the court said that privileges have a functional relationship to the discharge of functions as a legislator, and destroying public property in the name of protest by MLAs is not covered within the ambit of immunity and privileges afforded under Article 194. The court also relied on the landmark judgment of retired Justice Ripusudhan Dayal case, in which the court has made an observation that members only have those privileges which are essential for undertaking legislative functions. On another issue, that whether sanction of speaker is required or not, the court held that speaker's consent or sanction is not required before prosecuting MLAs in a criminal case. So the reliance which was placed on the landmark judgment of P.V. Narasimha Rao, in which the court did hold that the consent of the speaker or the chairman is required, was made in a different context, as the prosecution in that case was for the offences under the Prevention of Corruption Act, which did require sanction of the authority. So the finding of P.V. Narasimha Rao is not applicable in the present context. The last issue was that whether privilege can be claimed for the video recording that has been retrieved of the incident, and what is the admissibility of such video recording. For the first issue, the court held that since the video recording of the incident was not by the authority of the House, it is not a proceeding for the purposes of Article 194(2) and therefore no privilege can be granted on this ground. On the second issue of admissibility, the court said that the question of admissibility of evidence is decided by the trial court and it is not within the jurisdiction of the Supreme Court under Article 136 to settle this issue. So the final decision of the court was that they upheld the decision of CJM and High Court, and they said that the consent for withdrawal from prosecution is correctly rejected. So this brings us to the end of our video. If you like this video, please like and share and subscribe to our YouTube channel.